are called to consider the state's motion to revoke probation. The court understands that the defendant desires to enter a plea of true to the allegations in the state's motion, but to do so pursuant to plea agreements between the defense and the state. I further announce that this hearing or these hearings are being conducted by remote video teleconferencing technology using the Zoom technology as the platform for the hearings. The hearings are also being live streamed on the court's YouTube channel, all of which is to make sure that the record reflects that we are complying with the orders out of the Texas Supreme Court and rules and regulations issued by the Office of Court Administration. The presentation of these hearings in this manner leads the court to further announce that all persons are prohibited from recording any portion of this proceeding, whether by Zoom or YouTube, using any manner, electronic, photographic, or otherwise, with the exception of the official court reporter, who is a part of this Zoom hearing and will be transcribing the proceedings just like he would do if we were in person in open court. With those understandings with respect to these two cases, what says the state?
Ready, Your Honor.
And the defense?
Ready, Your Honor.
Are you Lachelle Lynn Tondre?
Yes, sir.
Ms. Tondre, the state has filed motions to revoke probation in each of these two cases that I have called. Have you received copies of the state's motion to revoke probation in these cases?
Yes, sir.
Do you understand that in each motion to revoke, the state alleges that you have previously been placed on probation in the respective case? They further allege that you have violated the terms of the probation in each case, with particulars stated in the motion. They request that as a result of the violations they claim have occurred, that your probation should be revoked and that you should be sent to the penitentiary.
Yes,
Do you understand these are the allegations in these motions?
Yes, sir, I understand.
Understanding the allegations in the motions, to the motion to revoke probation in cause number 9,880, how do you wish to plead? Guilty or not? I'm sorry, true or not true?
True.
And in cause number 9,881, to the allegations in that motion to revoke probation, how do you wish to plead? True or not true?
True.
Do you understand that you do not have to enter pleas of true? You have the absolute right to enter pleas of not true. And further, you have the right to thus require the state to prove those allegations and further, well, let me see where I want to go with that. And further, you have the right to not have it used against you if you exercise your right to enter a plea of not true, even if it were later found that the allegations were true. Do you understand that?
Yes, sir, I do.
In a motion to revoke probation, the law says that you have the right to have a reasonable time to prepare to meet the allegations or to defend against the allegations. The reasonable time is not specified by statute by number of days. There is another statute that says a person charged with an offense has the right to have a minimum of 10 days notice of the allegations before being forced to go to trial or required to go to trial. And so we have used 10 days as a presumptively reasonable time. I know that you have had more than 10 days notice of these proceedings.
Yes, sir, I have.
I usually state, and I'll state it again this time, if needed, I would grant even additional time to allow you to prepare. But that said, I have received documents entitled waiver of 10 days. In each case has one of those documents. And each of those documents say that the defendant is giving up the opportunity to have more time to prepare, which means the case will be heard today. And each of those documents have the signature you've already identified to the notary as your signature.
Yes, sir.
Did you know you were, in essence, saying, I'm giving up the opportunity for more time, and instead I'm ready for my case or cases to be heard today?
Yes, sir.
Mr. Keith, your signature is on each of these documents as well. Are you joining your client in these waivers?
Yes, Your Honor.
All right, I will accept the waiver of additional time and advise Ms. Tondre that there are some additional matters I wish to or need to visit with you about.
Okay.
First, I know there are plea agreements in the case. In each case, I don't have to follow the plea agreements in this type of a case, but I tell you, I will either follow the plea agreements, or if I decide not to, for some reason, if that occurs, I will let you take back your plea if true. But if I do accept and follow your plea agreements, then you will be bound by the terms of the plea agreements themselves. One of the terms of your plea agreements says that you are giving up the right to appeal in these two revocation cases. Ordinarily, a person has the right to appeal, even if it's a limited appeal, and even if it's a part of the plea agreement. But if a part of the plea agreement says you're giving up the right to appeal, and I follow that plea agreement, then that means what it says, and you cannot appeal. Your plea agreements have that provision marked. So it means if I follow your plea agreements, you will not be able to appeal. Do you understand that?
Yes, sir, I do.
Then let me ask a couple of other questions for you. Are you a citizen of the United States of America?
Yes, sir.
Where were you born?
Carrizo Springs, Texas.
I did. Say that again.
Carrizo
Oh,
Springs,
okay.
Texas.
All right.
Is that what you asked me, where I was born?
Yes, ma'am.
Okay.
I apologize. I just did not clearly understand you when you first
It's
said
fine.
Carrizo Springs. And then, of course, you added Texas, which
Sorry.
it's all right. My next question asks, do you consider yourself presently to be mentally competent?
Yes, sir, I do.
You know what's going on in these proceedings?
Very much so, yes.
Have you been able to understand the allegations in the motion to revoke so that you can discuss them with your attorney and discuss the facts that might be brought up in these cases? Have you been able to do that?
Probably more than he would like. Yes, I have.
All right. And have you been able to understand his representations to you about what the law is and how the law affects or might be affected even by the facts of your case?
Yes, sir.
Mr. Keith, do you believe your client is mentally competent?
Yes, sir, I do.
All right, I accept that representation, and it's obvious to the court. The court has dealt with Ms. Tondre in court before, is well aware that she is mentally competent, and I make that finding.
Thank you, Judge.
Ms. Tondre, next ask you, are you satisfied with the legal representation your attorney has provided to you in these matters?
Yes, yes, I am. The outcome, no, but his representation, yes.
Okay. And I only asked that question just to give you a chance to tell me if you thought his.
He was wonderful. He did fabulous. It was good.
Okay. That, quite frankly, that answers the rest of my questions about that. Then let me announce that those are all the questions I have at this time. Mr. Smith, you may proceed.
Your Honor, in each case, the state offers for evidence a document marked as State's Exhibit 1, each of those being this defendant's signed and sworn stipulation of evidence in its respective case.
No objection, Your Honor.
I apologize. I looked away for a moment and I didn't realize, Mr. Keith, you moved into another room.
I saw the same thing. I was like, whoa.
I was very fast.
Well, at least half. All right, Ms. Tondra, let me talk to you about these stipulations of evidence that the state has offered. Each one of them have your signature and have been notarized by the notary. They also talked about some other rights and admonitions that I do need to talk to you about. For one, you are entitled to, the legal expression is to confront the witnesses against you. That really just means you have the right to have those witnesses brought into court, even in a virtual court, so that you could see them and hear them as they give testimony, requiring them to give that under oath. The stipulation of evidence, however, says you're giving up that right to confront the witnesses, thus telling the state they don't have to bring those witnesses into court at all. Did you realize you were giving up that right when you signed the stipulations?
No, but it doesn't, I mean, sure, yes. I would
Well-
still waive it. It's fine. Yeah, I understand.
Okay. Let me make sure that I understand what you understand. I understand you to be saying that you understand you could require, just by asking, that the state produce their witnesses in court so you could see them and hear them as they gave testimony under oath.
I understand that. I'm waiving that.
All right. And by waiving, you understand you're telling the state they don't have to bring those witnesses into court.
Yes, sir. I get that.
The stipulation also says you're giving up your right to remain silent, and you're giving up your right to be free from self-incrimination, which is the right to not be forced to give evidence against yourself. Did you realize you were giving up those rights? Let me go on and say, not only are you giving up the right to be free from self-incrimination, you are, by signing the stipulations, incriminating yourself, because they amount to judicial confessions admitting the violations of probation alleged by the state in their motion to revoke.
Right, correct.
All right. And you are aware that that's what you're doing.
Yes, sir.
The stipulation in each case also says that you are aware that there are reimbursement fees in each case totaling $610 in cause number 9,880 and totaling $1,001 in cause number 9,881. Did you know those amounts were in the stipulations also?
Yes, sir.
All right, State's Exhibit 1, the signed sworn stipulation of evidence in each case is received as evidence in each case.
State rest, Your Honor.
Defense rests, Your Honor.
State closes.
Close.
All right, Ms. Tondre, in each case, cause number 9,880 and 9,881, based upon the evidence that was stipulated to and based upon your plea of true in each respective case, I find that the evidence is true and that you have violated the probation previously given to you in each respective case, and that based upon those violations, your probation should be revoked. Those pronouncements being made, do you know of any legal reason why a sentence should not be imposed at this time?
No, sir.
Then based upon your, you know what, I didn't discuss the plea agreements with you. Let me do that. I just want to make sure that I understand them the same way you do. The plea agreements in both cases say you will plead true, as you did and have done. It says that's going to result in the reimbursement fees of $610 and $9,880 and $1,001 and $9,881. There is some restitution set out in each plea agreement in the amount of $300 and $9,880 and in the amount of $1,317.50 in cause number 9,881. Each plea agreement says you will give up your right to appeal, as I discussed with you earlier. And each plea agreement says that you will be entitled to back time credits totaling 374 days in each case. Now, that's my understanding of the plea agreement in each case. Is that your understanding of the plea agreement in each case?
Yes, sir.
And are you asking me to approve these plea agreements?
Yes, sir.
Mr. Keith, have I stated the plea agreements accurately as you understand them to exist?
You have, Your Honor.
Mr. Smith, have I stated the plea agreements accurately as you understand them to exist?
Yes, Your Honor.
All right. Ms. Tondre, I told you I would tell you if I was going to follow the plea agreements, and I tell you that I will, in fact, follow the plea agreements. And so, having found that the allegations in the motion to revoke in each case, that those allegations are true, I hereby, and you knowing of no reason not to pronounce sentence, I hereby pronounce sentence by sentencing you to serve 10 years confinement in the Texas Department of Criminal Justice Institutional Division in each case. I order that you pay reimbursement fees totaling $610 and restitution fees totaling $300, both of that in cause number 9,880. Further, that you pay reimbursement fees totaling $1,001 and restitution totaling $1,317.50 in cause number 9,881. I've further grant to you the time credits that were a part of your plea agreements and set them out in the judgment in each case, those totaling 374 days in each case. I also announce that the sentences in these two respective cases will run concurrently. That means at the same time, and they are not stacked. They are concurrent. All right. That being said, do you have any questions, Ms. Tondre, about this judgment and sentence?
I don't think so, Your Honor. Thank y'all for your time. Thank you for your work, Trey. I appreciate you.
You're welcome.
And you too. Thanks for all the time you put in on the case.
All right. Your thumbprints have been affixed now on these judgments, and we will be in recess. Ms. Tondre, I want to wish you good fortune, not good luck. I don't mind if you have good luck.
I don't believe in luck, but yeah.
I don't either, and so I want to wish you good fortune. And I hope you can finish these sentences quickly and get back out in society, and that we will never see you again in this type setting.
Praise the Lord, you won't. Hey, Judge Armstrong, thank you. I've known you for almost 10 years now, and I hear you're almost done. This is your last term, yes?
That's true. That's true.
Congratulations, you've done a great job. Go enjoy retirement.
Well, I got a ways to go to get there, but I'll have quite a few people cheering me on into it. Some wishing it were earlier. All right. Thank you. You may be excused.
Thank you.
Yes, ma'am. Lanny, when you get through with her, would you let me talk to you?
I'm sorry, sir. Go ahead.
Yes, sir. Would we would like to go ahead and bring Mr. Richardson in at this time.
Yes, sir.
Thank you. This is not a hearing in Mr. Richardson's case. I'm just basically going to advise him, introduce him to Mr. Keith, and inform him of the appointment.